Describe the purpose of an investment management agreement and investment mandate and list the contents of each. Understand that conflicts of interest between a FMC and a client are likely to arise and how they may be resolved. Understand how personal account trading can give rise to a conflict of interest. List the principles that may be applied by a FMC to avoid conflicts arising from personal account trading and the compliance issues involved. Describe the conflict between clients that may arise in relation to allocation of stock. Define what is meant by soft dollar dealings, how a conflict of interest may arise in relation to such transactions, and how it can be properly dealt with. Appreciate the need for a FMC to keep proper records and accounts and to clearly segregate client assets. Understand and be able to apply the Securities Commission's requirements relating to client reports. List of topics. 1.0 The Investment Management Agreement. 2.0 Duties to Clients. 3.0 Records and Segregation of Assets. 4.0 Substantial Shareholder Notices. 5.0 Insurance Cover. 6.0 Summary. The IMA between the FMC and the client should contain the client's investment instructions in relation to the investment portfolio. The FMC must therefore receive written investment instructions from the client. A FMC must ensure that the written agreement includes client's risk profiles and investment objectives, including any investment limitations, Restrictions or instructions. Notification of any significant changes to the investment policy or investment recommendation. Clear authorization from the clients for discretionary mandate. Scope of services that will be provided by the FMC, including frequency of written statements and reports relating to the client's portfolios. Fees and charges to be paid by the clients or any other remuneration received by the FMC from any other person in relation to services provided to the clients. Details of custodial arrangement. Basis of valuation to be used for any type of investment products. TANC relating to soft commission, where applicable. Liability of FMC where there is a breach of the IMA. Conditions for alteration and termination to the IMA and its implications thereof in respect of settlement, repayment obligations and surrender of documentation, and details of delegation of the FMC's function, if any. In another one of its guidelines on unit trust funds, the SC requires an agreement between the management company or trustee and its delegate or service provider contain, among others, clear provisions in relation to the services to be provided, the fees, remuneration and other charges, any restriction or prohibition, reporting requirements. FMC's duties include the management of the client's portfolio on the basis of specific instructions from the client described in the IMA. An investment mandate sets out the client's instructions concerning the asset allocation of the portfolio, benchmark and prohibited investments. A disadvantage of incorporating the investment mandate within the agreement may not be amended by the client in response to variations. Investment. A description of the FMC's investment style and investment approach. Identification of the type of mandate e.g., balanced or specialist sector. Asset allocation ranges, where relevant to the type of mandate, including details of how exposure to each asset class is to be measured e.g., physical exposure and exposure through derivatives. A description of the FMC's investment powers. Details of the authorized investments. The extent to which the FMC may use derivatives e.g., only for hedging purposes, and the methods. Counterparty credit limits, cash, fixed interest, OTC derivatives. Gearing restrictions. Related party investments. Impact of taxation. Foreign currency management. Securities lending and borrowing policy. Performance, not a current practice in Malaysia to include an investment mandate. Benchmarks. The inclusion or otherwise of FMC's fees in measuring performance. Performance attribution. The impact of taxation on performance measurement. Other issues. FMC's policies in relation to corporate governance and proxy voting, related party dealings. Restrictions imposed on the investment portfolio by legislation, trust deeds, etc. Time limit for remedying non-compliance with investment restrictions applicable to the portfolio. A FMC in accordance with the investment mandate may use derivatives as part of a client's portfolio. A derivative instrument is a contract derived from a fundamental security that provides benefits to clients by way of increased execution efficiency, improved investment returns, reduced costs, risk separation. Risk using derivatives involves with market risk, credit risk, operational risk, legal risk. A FMC may, with the approval of its client, can appoint third-party investment managers to be responsible for investment of a part of a client's portfolio. The third-party investment manager may be a related party of the FMC. A FMC acting in relation to a unit trust should be aware of the SC's requirements set out in the guidelines on unit trust funds. The terms of any agreement between the FMC and the delegate would be agreed with the client. The prudent investor rule. Adhere to the fundamental fiduciary duties of loyalty, impartiality, and prudence. Maintain overall portfolio risk at a reasonable level. Provide for a reasonable level of investment diversification. Act with prudence where delegation occurs and, in the selection and supervision of agents. Be cost-conscious when making investments and particularly in relation to the expected level of returns from those investments. 2.2 Conflicts of interest. 2.3 Personal account trading. 2.4 Crossings between clients. 2.5 Allocation. Soft dollar dealings. The brokerage supply various products and services that are produced by a third party. E.g. performance measurement analysis, external research services, software, e.g. for portfolio modeling and technical analysis, economic analysis and stock quotation systems. In the US, minus 20% of total institutional commissions, in the UK at 15%. Clause 11.33 and 11.34 of the SC's Guidelines on Unit Trust Funds states the following. A management company, a trustee or its delegate should not retain any rebate from, or otherwise share in any commission with, any broker/dealer in consideration for directing dealings in a fund's property. Accordingly, any rebate or commission should be directed to the account of the fund concerned. Notwithstanding the above clause, goods and services, soft commission, provided by any broker/dealer may be retained by a management company or its delegate, but only if the goods and services are of demonstrable benefit to unit holders and a. dealings with the broker/dealer are executed on terms which are the best available for the fund, and b. the management company's or delegate's soft commission practices are adequately disclosed in the prospectus and fund reports, including a description of the goods and services received by the management company or delegate. In other situations, whether the practice of soft dollar dealing is appropriate or not is an issue to be decided between a FMC and its client. From a FMC's perspective, soft dollar dealings allows products and services to be obtained in substitution for broker research that may not be needed, the cost of which continues to be borne by the client through brokerage on transactions. Ultimately, the receipt of more focused and relevant products and services is to the benefit of the client. An alternative would be to raise the investment management fees charged to clients to pay for such products and services. Soft dollar dealings have the potential for abuse where there is no direct benefit to the client. In this regard, refer the Guidelines on Compliance Function for Fund Management Companies, which makes provisions for soft commission arrangements. Pursuant to the Guidelines, FMC must not accept or receive any rebates arising from transactions or orders on behalf of clients. Any rebates received must be directed to the account of the relevant clients. However, FMC may accept or receive soft commission arising from transactions or orders on behalf of a client provided that the client's prior consent has been obtained. Goods and services are of demonstrable benefit to the client, and goods and services are in the form of research and advisory services that assist in the decision-making process relating to the client's investments. U.S. lawful and appropriate assistance to the money manager and investment decision-making responsibilities. UK, which can reasonably be expected to assist in the provision of investment services to the firm's customers. An investment manager may enter into a soft dollar arrangement on behalf of a client providing 1. The goods or services acquired are of demonstrable benefit to the client. 2. The cost of dealing will not disadvantage the client compared with similar dealing otherwise than under the soft dollar arrangement. 3. When a broker acting under soft dollar arrangements acts as principal, the notional brokerage charge should be at the same rate as a similar size transaction on an agent basis. 4. There are no cash or money rebates involved which could be constituted to be a secret commission. 5. The total commitment made on behalf of all clients of the investment manager for such arrangements does not jeopardize the manager's ability to continue to maintain adequate financial resources. This brokerage limit should be prudent and reflect the nature of the manager's business, its level of capital and reasonable changes in market circumstances which could be expected. The manager's policy towards its limit should be expressed as a maximum percentage of the total brokerage generated on each of its clients' funds and stated in submissions. 6. Details of the manager's policy regarding soft dollars should be contained in all submissions and management mandates. A statement of compliance with the stated policy should be contained in all reports to clients on an annual basis or as required by the clients. 7. On request, any information relating to how the manager's soft dollar policy affects clients individually should be made available to the client. A potential conflict of interest through a stockbroker that is a related party of the FMC. The guidelines on unit trust funds state that the management company and trustee should take all reasonable steps to ensure that any related party transaction, dealing, investment and appointments involving parties to a fund must be made on terms which are the best available for the fund and which are no less favorable to the fund than an arm's length transaction between independent parties. In approving the broker/dealer, the investment committee should be satisfied that the dealings in the fund's property will be affected by the broker/dealer on terms which are the best available for the fund, best execution basis, and should prescribe a limit in terms of proportion of dealings, in percentage executed with each broker/dealer. The use of any broker/dealer for a fund should not exceed 50% of the fund's dealings in value in any one financial year of the fund. The guidelines also require disclosure in the annual report to unit holders of total commissions paid and the proportions and amounts paid to related party stockbrokers. While the practice of a FMC retaining rebates from stockbrokers, based on commissions charged to the FMC's client, is not in accordance with the SC's guidelines where the client is a unit trust, it is also considered by some FMC to be improper in relation to other types of client. Certainly, authority from the client to retain such rebates should be obtained in advance and the amount retained should be disclosed to the client at regular intervals. The practice of retaining rebates is often linked to the frowned-upon practice of churning. Churning relates to an excessive level of transactions in a client portfolio made with a view to generate additional commissions, in the case of a stockbroker, or rebates, where a FMC is also involved. Any transactions made primarily to benefit the FMC, rather than being in the client's best interest, is likely to be a breach of the FMC's fiduciary duty. The requirements of a FMC relating to the keeping of records and the segregation of assets are laid down in the Investment Management Agreement and in the CMSA. An investment management agreement will generally refer to the appointment by the client, perhaps after consultation with the FMC, of an external custodian. A custodian safeguards and maintains assets which comprise the portfolio, e.g., shares, liquidity, etc., on behalf of the client. It holds the assets in its own name but on behalf of the client who retains beneficial ownership. The custodian makes settlements for securities bought and sold, collects income arising from the portfolio, and pays expenses as instructed by the client. Amounts may be transferred into and out of the portfolio in accordance with the client's instructions. An external custodian, such as a trustee company, provides the client with an additional layer of protection. Since special skills are required of a custodian, especially where international investments are held or where there are a large number of client portfolios to be separately maintained, it is generally uncommon for a FMC to provide this service. However, a trustee company need not be appointed as a custodian in all cases. The Investment Management Agreement will prescribe the arrangements for dealing with client assets, for example, allowing for authorized employees of the FMC to initiate settlements and for the timely provision to the fund manager of the amount of available liquidity held by the custodian. The CMSA requires a FMC to maintain a trust account for client monies and property and to make arrangements for a licensed custodian to maintain that account, S.122. A separate record is to be maintained for each client, S.123(1)(c). Not to do so is an offense. The holder of a CMSRL who carries on the business of fund management may not accept nor hold client monies or property unless the representative does so on behalf of a FMC and in the course of the representative's employment with that FMC, S. 122(7) of the CMSA. SC requires that a FMC provide statement relating to a client's portfolio directly to each client, at least on monthly basis include a statement of account showing the client's actual portfolio position and the fees and charges payable by the client. A FMC must also provide, at least on quarterly basis, reports to its clients on the performance against appropriate benchmarks. Any changes in risk, if any, and any impact on the client's capital and earning arising from the change in risk,